and welcome. I'm Amritanshu Rai and you're watching Law of the Land on Rajya Sabha TV. Today we bring to you the guidelines laid down by the Supreme Court on the issue of adoption. These guidelines evolved into what are the Central Adoption Resource Authority CARA guidelines on adoption. CARA is now the nodal agency for all adoption in the country. To discuss the issue, I have with me Dr. Bharti Sharma, former chairperson, Child Welfare Committee, and Dr. Vinita Bhargav, Associate Professor, Department of Human Development and Childhood Studies, and she's also the founder member of CARA. Now for the headlines. According to the law of the land, citizens in a live-in relationship are not allowed to adopt. Single parents are eligible to adopt but can adopt children of the same gender only. And we take a look at the 1984 judgment of the Supreme Court which initiated guidelines for adoption. The adoption guidelines prohibit citizens in a live-in relationship to adopt. Any couple who has a stable marriage for at least 2 years can adopt a child. A single parent is also allowed to adopt a child. These guidelines have been framed by the Central Adoption Resource Authority, CARA, which is the nodal agency for all adoptions in the country.
These sweet angels don't know any legal language. The language they know is of love and care. So it is the responsibility of every individual associated to these adopted children that they should get love, care and safety. This is the recently launched web-based child adoption guidance system. All a prospective parents need to do is to register online and track the progress of their application. The web-based system has information about availability of children and the list of licensed agencies who will facilitate the adoption process.
We have introduced the new guidelines governing adoption of children 2011, and simultaneously we have introduced online application through Carings, that is known as Child Adoption Resource and Guidance System, that's IT application. And also we have mandated that all applications, adoption applications should proceed under Juvenile Justice Act.
Let's look at the process that needs to be followed to adopt a child. The prospective parents seeking to adopt need to register with the nearest local licensed adoption agency. The agency then conducts a home study of the prospective parents. During this process, all the inquiries and apprehensions of the prospective parents are addressed, and an assessment relating to the ability of the couple to parent a child not born to them will be made. The prospective parents will then be required to submit documents related to their financial and health status to the agency. On being satisfied with the process, the agency will then arrange for the child to be shown to the parents. If desired by the parents, the agency will take care to match a child meeting to desired description. Once the prospective parents are satisfied, the agency files an application for obtaining the necessary orders under relevant laws. After the application succeeds, the adopting parents will have to pay the agency the government prescribed maintenance and legal cost. After the child is handed over to the parents, there are follow-up visits and post-adoption counseling by the agency till the child adjusts to the new environment.
We have introduced the new adoption guidelines and the IT application to bring more transparency in the system and also ensure that the adoption agencies are ethically involved.
You can adopt a child under the Hindu Adoption and Maintenance Law or under the Juvenile Justice, Care and Protection of Children Law. But before adopting the guidelines of the Central Adoption Resource Authority, CARA, and the principles laid down by the Supreme Court need to be fulfilled. Aruna Thakur, Rajya Sabha TV.
Last year alone, over 6,000 adoptions took place in the country, out of which nearly 600 adoptions were done by foreigners. Ma'am, the question to you first is, the adoption happens under JJ Act and the Hindu Marriage Act. These are the two principal laws for adoption. Now, does it actually facilitate adoption, the way these two acts are present?
See, Hindu Adoption Act is absolutely for those who are following the Hindu religion. But our country is a secular country. And what about those parents who are non-Hindus?
Right.
It is JJ Act, which is a non-secular act. And that is the reason why, it's a secular act.
Yes.
And that is the reason why under the JJ Act, you can adopt any person following any kind of faith can adopt a child. And there are no restrictions. As we know, there are personal laws also.
Yeah.
But personal laws in many cases are very restrictive in terms of adoption. And here is a place where a citizen of the country who is non-Hindu can also legally adopt a child. Otherwise, it used to be under GAVA. Now, GAVA would mean guardianship. It's not a full adoption.
Yes, it's guardianship.
Yes, that means we are depriving what we are trying to do through JJ. Child is the primary
Focus.
When child is the primary focus, and if we go with GAVA, where are the interests of the child taken care?
Absolutely.
So it is very important that GAVA as it is all right, but when we talk of adoption, it has to be where our primary focus is the child and the secondary focus is the family. We go in for adoption under JJ for the best interest of the child and not for the best interest of the family. Of course, there has to be matching, but child is the primary focus.
Do you think it's time for us to go in for a standalone only law for adoption?
I absolutely am for it, because there are a lot of things in CARA which I'm sure you are going to talk about. See, CARA is guidelines. There is a difference between guidelines and the statute. Statute is more powerful.
Yeah.
And if we are talking of guidelines, guidelines do not have those penal provisions. Supposing something goes wrong in at so many quarters in the whole process of adoption, and it is, we don't have to feel shy of accepting that there are
Problems, issues, yes.
there are very, very strong issues. Now, no penal provisions. Is the statute, if we have a law on adoption, and on adoption only.
It will eliminate such problems.
It will.
Now, coming to the issue of CARA, ma'am, you were explaining the issues, the basic problems that CARA, the problems that have come about because of the new CARA guidelines.
I'd just like to also focus on your earlier question to fill some of the gaps. What was the Hindu Adoption and Maintenance Act that did not really allow Hindu families to adopt another girl child.
Okay.
Or maybe twins. So, because under the Hindu law, you could adopt one male child and one female child. And there were a lot of Indian families who were coming up to say, we have a girl child and there's so many girl children in the country. Why can't we adopt another girl child? And if they went to adopt as Hindus, they were told, no, the second girl child you can get only under guardianship and what's
And that is where JJ Act came.
And that is where, if the JJ Act was there, even Hindus, it's not only about the non-Hindus, but a lot of Hindus who had girl children and wanted to go in for a second girl child, it made it possible under the JJ Act. Also, what is very critical and important to understand today is that the profile of children who are being abandoned and relinquished is changing. I mean, it has changed actually. If you go to an institution, you will find many older children. You will find many more children with disabilities. You will find sibling groups. You will have 3 children, of different age groups present together, left together. Now, looking at that scenario, earlier there were parents who were coming who were infertile couples only. So they wanted a young baby, very small, who they could care from right from birth, because they haven't actually experienced that kind of the experience of parenting a child.
Parenting.
So therefore, that was very critical. Today, we have that section of, people who want a child because they have not fulfilled that role. But we also have a huge range of others. Like, for instance, you were talking about, live-in relationship. I know when the guideline came up, I had a call from a huge number of people who were feminists or activists who said, what is this about? I said, well, I'm not going to, I'm going to address it as a child development, human development person, where I'm saying, okay, what happens to this child when the child goes into this kind of thing? There is no legal provision.
Sanctioned to a live-in relationship.
Yes.
And the law of the land doesn't allow or acknowledge a live-in relationship.
But that is not to say that over the last so many years,
These
I do not
exist.
know. I mean, I know a number of
These
people
relationships exist.
who have adopted as individuals.
Oh.
So they have not disclosed that they
Single parents.
As single parents.
Which is allowed.
Which is allowed.
Which is
so
allowed.
you also have, even in, when we are sending children an inter-country adoption, when they disclose their status and say that we have a live-in relationship, they are not given
permitted.
a child.
The moment
same
they
way
say
with
single,
India. When they say that I'm a single parent, I have this other lady who's living with me because, we share the house.
But with a single parent, the accountability is much more higher.
So it is the interest of the child. So the child legally is the responsibility of that particular person.
On that note, ma'am, it's time for us to head into a break. When we come back, we will show you the first guidelines laid down by the Supreme Court. Welcome back. Adoption was a complex process and there were complaints of abuse as there was no legal framework for it. The Supreme Court stepped in and filled the void in 1984 by laying down extensive guidelines. Let's look at the guidelines laid down by the Supreme Court on the issue of adoption, which were later incorporated by the Central Adoption Resource Authority, CARA.
The basic premise for laying down the adoption guideline by the Supreme Court was that in absence of biological family care, an appropriate alternative for family care should be considered for a child. The court held that every child has a right to grow up in an atmosphere of love and affection and of moral and material security. In absence of a natural family, the next best alternative is to find adoptive parents for the child.
There is a definite need to create a law, number one. We should also cover the illegal adoptions. Illegal means which are made primarily for money, which are made for the reason that the child is being smuggled, the child is being trafficked, and then in the name of adoptions.
The Supreme Court in its landmark judgment on adoption said that the child should have the opportunity to be adopted first by Indian parents and secondary option should be adoption by foreign parents. In case of adoption by foreign parents, every application to adopt a child must be sponsored by the Social or Child Welfare Agency recognized or licensed by the government of the country in which the foreigner is a resident. No application by a foreigner for taking a child in adoption should be entertained directly by any social welfare agency in India. The order also said that if a child is to be given in inter-country adoption, it will be desirable that it is done before the child completes the age of 3 years. In case of foreigner who has been living in India for 1 year or more, the court should not insist on the sponsoring of such foreigner by a child welfare agency based in the country to which such foreigner belongs.
I would make an appeal to all our MPs to consider the issue of adoption, and just as we have a special marriage act, we should have a uniform adoption bill, because people should not be apprehensive of the bill. After all, it's only an enabling law. Nobody is forcing you to adopt, but those who adopt should ensure that the children have all the legal rights, and only a uniform adoption bill can ensure that.
The judgment clearly states that before granting adoption to foreign parents, the authorities need to safeguard against the child being neglected or abandoned by the adoptive parents in the foreign country. The authorities also need to take care that the adoptive parents are able to provide the child a life of moral and material security. According to the order, the authorities need to assess before granting adoption to foreign parents that the child is not subjected to sexual abuse, post-labor medical research and experimentation. History is the evidence that Parliament was not successful to enact uniform adoption law. An expert view is that uniform adoption law is the only solution for the betterment of adopted children. With camera person Siddharth, Aruna Thakur, Rajya Sabha TV.
There were reports during that time, that is around 1984, that children were being sold, transported and trafficked to foreign countries for prostitution, removal of organs and for other reasons. These issues were brought to the notice of the court by an advocate named Laxmi Kant Pandey, which resulted in the guidelines for adoption. And from there on, the movement began, and now we have what we call the CARA guidelines. Ma'am, the question to you is, what are the existing issues with the CARA guidelines? Where are the problem areas?
When the original judgment was passed, there were certain structures that were put in place. Like you had the central body, you had the VCAs, and you had the state government which had a role, you had the scrutinizing agencies, and all these various agencies and their roles were spelt out by the court. There were issues, and some of them over from 1984 to 1991, there were a lot of issues that were looked at and then thrashed out. And
there were three succeeding judgments which clarified the entire original judgment.
Thing. Subsequent to that, the country signed the Hague Convention.
Yes.
And being signatories to the Hague Convention, we also had to see that we followed certain
international parameters.
And therefore, what major change that took place was that you had licensed foreign countries who were associated. I mean, the licensing was done by CARA, but they were individually associated with various
other agencies,
local NGOs, recognized by by CARA and the state government, licensed by CARA and the state government.
But that is prohibited clearly.
No.
By the Supreme Court judgment.
No, it's still there, but now it has to go centrally through CARA. All agencies have to now,
guidelines.
After the most recent guidelines, no agency can have a direct contact with the local agency. So all dossiers of children have to come through through CARA, and then they have to be forwarded by CARA to the various agencies, looking at where the children are. Also, subsequently, what has happened is some of the structures have got like amalgamated. Like for instance, the VCA, which used to do the coordination of children and parents, for instance, in a state, if there were more children available in a particular agency and more parents in another agency. So the VCA used to keep all these rosters of children and parents and send the parent off to a particular agency where there were children. And only after sufficient effort was made in placing the child, was the child given an NOC. That is a no objection certificate or a clearance that now you can find a foreign family and place the child there. Now, because of this new guideline, the VCA, the ACA has merged with the state government, which is called SARA. And now directly, once the file where the parent and the child have been, put together, the file comes to SARA. Now at that point, SARA says, well, this doesn't look okay. There are lots of families waiting for...
there is the duplicity.
So what happens is, at this point, if you tell a particular agency that, well, there is a family, you please place this child with this family, already a lot has happened with...
the
other family, and it's inhuman because after all, they're also parents, and many of them...
How can it be sorted out?
I think either SARA should again have the same kind of function, role allocated, which has been removed, because they've said that we've given the agencies a quota. You have to do 80% in country, 20% inter-country. So it doesn't really matter whether that 20% of children can be placed in the country or not. Now that is a strange argument, because on one side you have the Supreme Court guidelines, which says every child has...
First priority.
Yes. So every child. It is not about 20 and 80 quota.
Absolutely. And so if it has to happen abroad, then below 3 years, before the actual forming begins of the mind.
No. That's another completely different topic that we are going into, because most of the children who go abroad are above the age of 3 years. because there are very few Indian families who are willing
I was
to
talking
take.
of the Supreme Court
Yes.
judgment. I'll get you in, Dr. Sharma. On the illegal adoption bit, do we have anything, and what exactly is illegal adoption, and do we have any mechanism to prevent this activity?
Yeah, this is very, very relevant question from your side. See, what is happening is not that we do not have children. If we ask the specialized adoption agency, then they have a long list of parents waiting to adopt a child. Does it mean that we are short of children? No. There is a lot of illegal adoption that is taking place from the hospitals, from the nursing homes, also from various other sources. And there is a lot of trafficking that is taking place. We do not have very stringent trafficking laws. All these things that is taking place, this I would call trafficking. From the nursing homes and hospitals where there is exchange of money.
Absolutely, for
And
the
when
child.
there is an exchange of money, nobody is doing this for nothing. Everybody is getting some gains, financial gains, and this is trafficking. And our trafficking, our IPC on trafficking
Is very
not
weak.
quite, yes, is weak, is not quite addressing all these issues. So
But
what is
Supreme Court has filled in a lot of that gap. But implementation is the problem.
implementation is problem throughout.
Throughout.
In fact, is a problem throughout.
Right.
Even at the district level, what is happening in the metropolis is one thing, is much better. But when you go to the district, you do not even find the structures.
Available for any activity. Time for us to head into a break. When we come back, we will show you an interview with Advocate Jagdeep Kishore. Welcome back. My colleague Aruna Thakur spoke to Jagdeep Kishore, advocate, and tried to get his point of view.
Tell us about the Supreme Court landmark judgment of Laxmi Kant Pandey, which gives a platform to the adoption law in India.
See, Supreme Court guidelines were issued when there was no law, and those guidelines were directions were in the form of the judgment in Laxmi Kant Pandey, which came in 1984, 85, 86 through till 91. From time to time, directions were issued. At that time, there was no Juvenile Justice Act. At that time, India was not a signatory to the Hague Convention on Rights of the Child. So therefore, at that time, Supreme Court directions were the law. And we were all processing those cases, inter-country adoption cases, under those guidelines or directions.
Kara was also the outcome of that Supreme Court judgment. So tell us briefly about Kara and the principal legislations which is dealing with the adoption law in India.
After India became a signatory, Kara was also set up pursuant to those directions of the Supreme Court. Then Kara took up the initiative of setting up these directions, these guidelines from time to time. And then came the Juvenile Justice Act. The Act of 2000 was deficient in certain respects. It did not allow the processing of cases for adoption. But in 2006, that amendment was brought about, whereafter we have now started processing cases under Juvenile Justice Act.
Recently, Kara has laid down guidelines to strengthen the adoption law in India. So what is your observation on this?
These Kara guidelines have mentioned no single male should be given a female child. Hindu Adoption and Maintenance Act has recognized since 1956 that a single male Hindu can adopt a female child provided the age gap is 21 years or more. A single female Hindu can adopt a male child with the same condition of 21 years. Now, when the statutory law permits that, a guideline cannot overrule that. So, to that extent, it needs to be modified. The other category is live-in parents, which the Kara guidelines has dealt with. We are in a progressive society. Live-in relationship is recognized by Supreme Court. The wife is entitled to certain benefits out of that live-in relationship, maintenance and other things. Now when the courts are moving forward with the changing values, with the changing times, why should the law also not move accordingly?
A citizen can adopt a child under the Hindu adoption and maintenance law or under the Juvenile Justice Care and Protection of Children law. Ma'am, the point I would like you to address is, what is the problems that are happening because of the various levels of structure and guidelines that have come into place, and the compliances that follow up? What are the implications, and very quickly, ma'am?
Compliance, in terms of compliance, I would say that as far as metropolis are concerned, there is good compliance. But when you go at the district level, as I shared earlier, the structures are not there, and so there is a delay in the legal adoption matter. But actually, to the best of my knowledge, I do not know why people so much complain about delay. You cannot expect, see, we are looking at the best interest of the child. And when we are looking at the best interest of the child, it is very important that we are very sure as where we are placing the child.
Right.
And when we do that, it just can't happen like that. It's
has
going
to take
some time. And secondly, what I would like to say is, how many months you wait to give a birth to a child?
9 months.
9 months.
So wait
and
for
here,
equally.
Yes.
Okay. Ma'am, the point on follow-up, especially if the child has been adopted by people
I would also
abroad.
like to raise that it is not that the parent cannot wait. What I'm saying is, being from a child development perspective and a specialist in child development, the first 3 years are the most critical for brain development. If those 3 years are spent by a child in institutional care, this child is going to be affected for life. No,
Okay.
for life, because
get it.
brain development is going to affect somebody's entire
And that is
being.
being lost because of compliances.
Not because of compliance, because we are not taking it as urgently as we should.
Right.
Very often when we see that a child has been abandoned at the age of, say, 3 months or 1 month even, there are times when the police may take a long time to give their report. The CWC again is not very sure. So it ultimately, sometimes we see a child who has come in at the age of birth and has not gone in adoption up to 3.5 years.
That is where we lose out.
That is where the child's whole development is impacted and the best interest of the child is lost.
Okay, ma'am, last point.
There is one provision, both in the JJ and in the guidelines as well, CARA guidelines, that there is a provision of pre-adoptive foster care. And we are weak at pre-adoptive foster care. If we actually insist on this and put the whole system in place, I'm sure I agree with you on that part, that institutional...
This problem could be solved.
It can be solved.
Thank you, ma'am. Thank you, ma'am, for joining us on this discussion. It's time for us to end the show. You can email your suggestions and comments to law.rstv@gmail.com. You can also watch our shows on the YouTube. We'll be back with a new issue and a new episode. Keep watching Rajya Sabha TV.